Okay. Let's take a look at this. So we have S. They convey to B. You all can see this, right? I'm going to go with yes on
We
this
can
side.
see it.
Okay, great. Thank you. Yeah, I lost the chat. All right, so here we go. S to B, and then S to C, who does not record. So because this is step 1, this is step 2. Here, at this point, C has a superior title. Okay. Then C conveys to D. D doesn't record. And we also know that D knows about S and B's relationship here, right? So then we have C recording here. Then we have B recording. Then we have D recording. Okay. So the question was, how would we expect B to have notice? Well, in this case, B, I think the shelter rule isn't hurting anybody. And so, because you have to remember, B took, what do I mean? What do I mean by that? Can you say that in a clear way? B took up here, okay? And B just didn't record all the way to down until down here. So B, when would you check to see if there is a prior interest? Well, you would check to see usually before you record. So at this point, he would have seen that C recorded. B would have checked here, C would have recorded. So the idea with the shelter rule is that they would have been on notice at least of C's recording. And even if they hadn't been on notice, the idea of the shelter rule is that that you check before you take original title. So B would have probably checked up here. So there would, it wouldn't have affected the outcome, if that makes sense. The only place it would affect the outcome is in a race jurisdiction, but not in a notice race jurisdiction or a notice. I hope I explained that a little bit better. And here you can see too, clear that D, although D knew, D wouldn't qualify as a bona fide purchaser. They're not a bona fide purchaser here, right? But because C is a bona fide purchaser, they pass on to D their bona fide purchaser status, and they recorded here. And so B is a, that's what the shelter rule is. The bona fide status gets passed on to D. So even though D is not a bona fide purchaser, they can still take. All right.
Professor, really quick.
Yes.
So if C was also not a bona fide purchaser, would that pass on as well?
Correct.
Okay.
Well, let me rephrase. If C was not a bona fide purchaser, let's go back to the rule, then the rule wouldn't apply. So it's not that it would pass on. It's not that the lack of status would pass on. It's just that the shelter rule would not apply. If I could get this to work. That's not me.
Okay, so really quick, sorry, just to clarify.
No, go ahead.
So let's say C knew about the B deed, but D did not. So D's still a bona fide purchaser in this case?
So
C was not. You see what I'm saying?
Mm-hmm. Okay. Mm-hmm. C conveys to D, and C is not a bona fide purchaser. But are we changing this fact pattern here? Are we saying that D did not know?
It was just swapping C and D's knowledge, essentially.
Okay, so we had another question about that, actually, with similar facts, and that was hypo number 1. So if I switch, I'm going to switch back. Oh, where did you go? I'm sharing my screen. I don't understand. WebEx. Sorry, guys. I've been having WebEx issues lately, and I have no idea why. Okay.
Jess, can you hear me?
Yeah.
What are you wanting to figure out? Like what are you trying to figure out with your new HYPO?
So I'm just saying, because C's status of bona fide purchaser passes on, but if he is not a bona fide purchaser, but D is, like, does that affect the flow, or does D still get?
Absolutely, it affects the flow. Then you just look at who. Then you go to all right, first in a race jurisdiction. Who's the first one to record? You would check that off. Then in your next one, the notice. Who is the bona fide purchaser? Record, and then the next one is who is the first bona fide purchaser to record. So the shelter rule there wouldn't even apply because C isn't a bona fide purchaser. So D would just basically, if he's the first one to record in a race jurisdiction, he wins. If he's in a race notice and he's a bona fide purchaser and he's the first one, he wins. And then in the notice jurisdiction, if he meets all of the other requirements, he would win that as well. So yeah, it does change everything.
It does, and I was trying to move you to, here we go, HYPO 1, which is on, I think the same, I think it's on page 617. Could be wrong. But so for HYPO 1, here S conveys to C who knows about the SBD. So this is your fact pattern, I believe. And if you look at it, I'll make sure it's the right page I told you on 616. Which HYPO is this? Okay, so this is the HYPO you're talking about. I'm at a loss for which page this is at this point.
It's somewhere right around 623, maybe 625-ish or something like that.
Okay, it's on that side. Yep, there it is, around 625. Right, so it's not under the shelter rule problems, which is probably why you didn't, it didn't kind of connect. But what it does is it's the same fact pattern, but it's where C knows about the SBD. So in this case, C is not a bona fide purchaser, right? And D cannot, the shelter rule doesn't apply here because the shelter rule, which if we go back here, you see a bone only applies when there's a bona fide purchaser. Okay. So here you could try to apply the bona fide purchase rule and it wouldn't apply. Or the shelter rule, and it wouldn't apply because they're not bona fide purchasers. All right. Any questions now that I've got my computer unfrozen? Sorry about that.
Professor, in that case, in HYPO 1, you know, it's easy to see why D could never be a bona fide purchaser because B and C both recorded before him, and he has notice of B because B recorded first, right?
Yep.
But if B never recorded, so same facts, but let's move C conveys to D all the way up to underneath C conveying to C. Even though C is not a bona fide purchaser, D could still be a bona fide purchaser because he has no actual or constructive knowledge, even though the person he purchased it from did have actual knowledge.
Correct.
Okay, just wanted to make sure. And then I have another question. Sure. Going back to HYPO 4, what is the situation with C recording after he conveys the D? Is that just to show what he had before he conveyed the D? Or, like, I'm confused about recording after you've already transferred your estate.
Yeah, like, why would you do that?
I mean, I guess it's good to put people on notice you had it in the past. Or what confused me when I was doing the problems, I was like, is C trying to still claim he has title?
No.
Okay.
He's
Okay.
recording his original title, and it's the reasons why he may have done it or she may have done it is that maybe they realize that, oh, I probably should have done that because just in case, D needs that as proof. I don't want D to come back to me later and say whatever, so let me record, right?
Right.
You can
But
see if that
for
or
purposes
somebody
of
realizes, oh shoot, I didn't record.
right. For purposes of the quiz, though, we are going to be looking at knowledge at the time of conveyance, right? So unlike the Board of Education hypo, which was really odd to me because it seemed to be kind of an outlier, you would normally look at what was the knowledge at the time they were given the deed, right?
Correct. Yeah, I wouldn't. I really dislike it when book authors include cases that have like very odd state specific rules like this one because it can, it confuses students. And I think it's important to know that Sitkoff does do that sometimes if you haven't noticed. And so, just note that I will not test on odd state specific rules like this.
Okay. So for our purposes, we're just looking at when the conveyance occurred for what their knowledge is.
Correct.
Okay. All right. Thank you. That's really helpful. Thank you.
Well, you'll get the problem will say, now, what do we mean when the conveyance occurs? So you're gonna want to make sure that delivery was proper.
Right.
And the deed was accurate, right? So did the deed state this as long as the question says that, and the question usually does when it's multiple choice, say like the deed was properly conveyed or promptly, so you can assume that for if you had a multiple choice question, an essay question, like for the final, it would be worth prodding as to whether or not the deed was correctly.
Okay, that makes sense. But for like very simple hypos like this, you couldn't say C recording before B puts B on notice, because when B got the deed from S, the recording exists, right?
Because
We're taking this chronologically.
If you think about the conversation that I did with Barbara Stewart, when does Barbara Stewart or her paralegal do the title search, right? They do the title search right before the conveyance. Right. So the law assumes the title searches are done right before the conveyance.
Gotcha. Yeah, that makes perfect sense. Thank you.
Yeah, that's why I tried to do that interview. So I was hoping that the real world context could provide you guys with some, a little bit of way to contextualize a little kind of abstract concepts like recording. Yes,
I feel like there's the real world context and then the North Carolina context, but that's my personal opinion.
It's true, because in North Carolina, there's only 2 states that do pure race. But it was interesting was Barbara really felt like it was the more proper way to do it, because how could you expect somebody to have notice? And so it's interesting. It's very interesting. I thought it was kind of crazy that I didn't get my keys when I closed, but that's what it is. So. All right, let's move on from, so what was this one? The same thing. Okay, this is a good question about, can you ever have a contingent remainder subject to open, or subject to opens limited to vested remainders? You could definitely have a contingent remainder subject to open. So imagine if I had said A to B, A to B's children, A to B's children, if they go to law school, if the child goes to law school. Right? So you have a contingent remainder there because it's if they go to law school, and it's subject to open because the class, B's children, is an open class, meaning more kids can be added in, more people can be added in. So subject to open more so has to do with whether or not it's a class gift And subject to open just means that the class is still open and members can be added to the class. Okay, so this is about the rose.
Question about that. So if you're analyzing a RAP question, if it's contingent, subject to open, you wouldn't analyze RAP because it's not vested.
Well, no, you'd still analyze it for RAP. You need to make sure, because subject to open, you need to make sure that the class will close and that the contingent remainder will be satisfied before 21 years.
Okay.
What was the list that I gave you of the three? I don't have it in front of me.
It's vested. It doesn't say anything about contingent remainders subject to open, unless I'm wrong, but I'm
Does it say contingent remainders?
no.
It
It does
says,
say contingent remainders, it just doesn't say subject to open.
yeah, all contingent remainders.
Okay.
So the
There
three.
was a question on the quiz. I think that's why I got confused. I was going back over the quiz, and I unfortunately can't remember which one now, but it was one that was a subject to open until you analyzed RAP. And I was really confused why it wouldn't have been contingent and why it was vested at first. Or maybe it wasn't. I don't know.
Well, I'll tell you what, Erin, let's see when I circle back to it after I've gotten a chance to look at which one it is, or maybe after we both have a chance to look at which one it is, and then I can better explain it to you.
I thought I wrote it down somewhere, but I misplaced it. But okay, that sounds good. Thank you.
Yeah, I don't have it in front of me, so I'm not quite sure. I'm not quite sure which one it is, but contingent remainders should be one of the three that I gave you. I don't have the list in front of me, but I think it was contingent remainders, vested remainders subject to open, but it could also be contingent remainders subject to open.
Okay, sounds good. Thank you.
Okay, that's a good question. Thanks. All right, Rose and Grant. So Rose and Grant, the grantors wrote the grantor's name on the envelope, implying that he had the right to recall it. If there was any way to show that the bank screwed up and wrote his name on the envelope without being instructed to, could that have changed the outcome? Well, I think so. For Rose and Grant, right, part of the reason that the court found that there wasn't the requisite intention to deliver, right, to immediately transfer the property. And part of the reason in this case was because the court said that the grantor retained the right to recall or to take back the property, right? I think the court didn't just look at his name being on the envelope, but about the practices of that bank in particular. And their practices was to generally allow people to be able to come back and take the deeds. So, but let's say that this was at a different bank and they had used, so when you take wills and trusts, you'll understand that you can create a couple of things. You can create a trust where you say, you know, bank, I want you to hold this in trust for this person and give it to this person on the happening of a condition. If that condition is death, though, then these facts just lend themselves to a testamentary transfer. There are situations when, like you went over the HYPOs, when you can make a delivery with the intent of just giving, you've made the transfer at that point, but you just don't intend for the deed to be delivered till a future point. But you have to, in those situations, be 100% sure that the grantor doesn't retain a right to take it back. This was a good question about race states and valid deeds, about whether the transfer is valid even if it's not recorded in a race state. And the answer is sure. The race statutes and notice and race statutes and notice statutes, they have to deal with who has superior interest if there is a dispute over the claims. So as long as no one else's deed is recorded, then the deed is valid. We're not talking, there could have been valid delivery, there could have been, but the issue is the chain of title. And that's what race states and, race statutes and race notice statutes, that's what they deal with, the chain of title, who has superior title. And so that's where that would come in. So the deed is still valid, the transfer was still valid, but if it's not recorded, then subsequent purchasers can't know about it. And in states that are race states, they can't claim superior interest. Questions on that? All right, Mother Hubbard clauses. So Mother Hubbard clauses are clauses that have general property descriptions. And the key to know for the exam, I think, is that in situations, states will hold that property descriptions that are very broad and say things like everything, I give everything I own to my brother Sam. Okay, I give every property I own in Guilford County to my brother Sam. That would be a Mother Hubbard clause. It states that all property owned in a particular county can be transferred to Sam. Now, courts have held that that's a proper transfer, right? But that is not sufficient of a property description to put somebody on notice, even if that deed is recorded. Okay, so again, here we're talking about two different things. We're talking about whether or not it's a proper transfer, and courts have found it's a proper transfer. But then what about the chain of title? How do you establish that your ownership, or how does Sam establish that his ownership is superior to the ownership of others? And so as a general principle, yes, you should, as soon as possible, try to file some type of affidavit or whatever they use in that jurisdiction to have a property description, so that a specific property description for each piece of property, so that subsequent purchasers would be on notice and it would be recorded in the chain of title. Does that make sense? All right. Seeing none, it looks like I didn't fill this slide out. All right, let's talk about SAWADA v. ENDO approaches. Pull that up. Maybe you have a page number for this case. I found it. Looking in the wrong chapter. Okay. So the issue in this case, oh boy. The issue in this case was, this was the tenancy by entirety case, and they were talking about whether if one spouse has a debt, can that be levied on the other spouse's share of a tenancy by entirety? And they went into 4 different approaches, and they called them groups, right? So they talked about the first group, which says that it follows the old, really, really old rule. And it says that the possession and profits of the estate are subject to the husband's exclusive dominion and control. So that if it is the husband's death, sorry, if it's the husband's, he can bind the entire property. The wife does not have control. As long as it's the husband's creditors, then he can levy the debt on the entire estate. That is group 1. Group 2, or approach 2, is that the interest of the debtor spouse can be sold or levied for his debt, but it's subject to the other spouse's contingent right of survivorship, right? So, was there a question? Okay, so it says that the interest of that spouse, they can choose, the husband could choose in this case to levy his part of the property, but the other spouse, the non-debtor spouse, has to approve because she has a contingent right. Right. Group 3 was any attempted conveyance by either spouse is wholly void. And so just like they can't transfer their interests, they can't incur a debt on only half of the property. And the 4th right says that each spouse has a separate interest in the land, and that interest can be attached by creditors. That separate interest can be attached by creditors. So those are the 4 different approaches. I don't have a question on the quiz distinguishing between those 4, so at least for now, you don't have to worry about those distinctions. Okay, so this has to do with Stambosky and this. So Stambosky is another one of those interesting cases where, so we said the majority rule, we're talking about seller disclosures here. Seller disclosures. So seller disclosures, we said that at common law, the seller did not have a duty to disclose anything. It was buyer beware, right? The majority approach now is that if the seller knew or should have known about the condition, then they have the duty to disclose it. So, but the Stambosky court, and I think it was New York, they didn't follow that majority rule. Okay, they were more of a buyer beware. But what they did was they created this exemption that if the owner created the condition, then the owner had to disclose the condition that they created. Especially if it's a condition that could not be discovered. It's what they call latent conditions. So the majority, if we applied the majority rule to this question about whether there was a wiring issue in the home and the seller knew about it, then the majority rule would say, yes, you need to disclose. Now, I think STAMBOSKY is enough of a, I don't want to say it's completely a minority approach or an odd approach, but it's a bit of, it's one of those rules that I wouldn't worry about the test from it being used for the purposes of the multiple choice. I do think the court in STAMBOSKY did really mean to interpret creation to mean something that was literally created, to interpret it pretty narrowly, as opposed to something that was just actual knowledge. Because remember, other jurisdictions have that test for actual knowledge, and here we're talking about a condition. It's also a latent condition that was created by the seller. This was the ghost case of an Beaver. Any questions on that? All right, the silent consent hypos. So I believe silent consent hypos was referring to leasing property, and we're talking about whether landlords have to consent for a transfer by the tenant. So a transfer could be, so does the landlord have to consent to the assignment or to the sublease? That's what these questions are. So I'm trying to find the page number. Okay. I remember the issues with these. All right, so I would not worry about the silent consent hypos, and here is why. I feel that they are a little bit too gray for our purposes. So I'm going to quickly talk about some of them and explain why I think that is. All right, so the first one is about you opening up a wine store, and the landlord believes that drinking alcohol is morally wrong, and he's also concerned that the customers at the wine bar may become drunk, causing problems for others in the mall. And so the question is, what is commercially reasonable? Because remember, the majority jurisdictions allow landlords to withhold consent for transfer if it is a commercially reasonable reason and the lease is silent otherwise, right? So is it commercially reasonable? Is the lease silent otherwise? And the question, so rather than looking at these hypotheticals, these problems, because there is argument here for one, that it is commercially reasonable to assume that a wine bar may cause some people to become drunk and cause problems for other people. And I think that's what you guys all struggled with, is that, you may have known that the landlord's belief that it was morally wrong wasn't sufficient, but then, you were confused because it does seem like there is a commercially justifiable reason here. I think these hypotheticals were created more to have a discussion about the different scenarios. So I wouldn't, for each of these, there are arguments both ways. Instead of focusing your time on these landlord consent problems, which are on page 510 of your textbook, I would look instead at the preceding case, Kendall v. Ernest Pastana, Inc. And I would pay very special attention to the reasons, commercially reasonable objections that were given by the court, and the reasons that were given to not be commercially reasonable. And I would just make a list of those and kind of keep track of those. That I think is more important than looking at these hypotheticals, because I agree with you that there are arguments to be had for the first one, for the second one that had to do with the well, the greeting store card one is probably the clearest cut one, right? So we'll open a greeting card store. There's already another tenant in the same shopping mall that operates a greeting card store, and L is convinced that B's store will adversely affect G's store. That is more clear cut. It is commercially reasonable for a landlord to refuse a transfer of a lease for the purposes of tenant mix. And that's what this is. This is a question of tenant mix. But number 3, the one that comes after them, has to do with the comic book store versus, is that the one? No, not the comic book store. There was one that had to do with like a daycare center next to a pornography store or something like that, right? And that one, again, I understand why you would have an argument the other way. Okay. Looks like we're back to, I guess we're trimming the grass now. So, okay. I'm trimming the edges. Okay. I think that's it for the co-tenant rights and duties. Right, co-tenant rights and duties. So this question, which I guess I did not copy and paste here, and my brain, sorry guys. Yes, so this question talked about whether or not co-tenants have duties to pay rent, whether co-tenants have duties to pay for expenses or upkeeps. So co-tenant rights and duties as far as rent goes. Courts have held that if one co-tenant occupies the residence but does not exclude the other co-tenant in any way, then they do not have to pay rent. If one co-tenant is found to have used the property in a way that essentially evicted or did not allow the other co-tenant to use the property, then they are required to pay for all of the expenses that arise from them living there. And the ousted tenant can get a credit of sorts, right? So I would go back to, what page was this? It was like a long time ago that we did these.
So I've got a question on this one right here, this specific issue. And so say me and Brady, we were tenancies in common with a beachfront property, right? And Brady was married. He went through a nasty divorce and he needed a place to live. He got kicked out of his house. So he calls me, says, I'm going to use the beach house for the next 6 months to a year so I can get back on my feet. And I say, that's cool, man, no problem. During that time, while he's living there, am I, as a co-tenant with him, am I going to be responsible to pay half of the electric bill and half of the water bill if we're both equally 50% tenants in common? Or will he, since he's the only one using it, is he going to be responsible for those expenses by himself?
That is a good question. Okay, so if he is living in the house, and so the operating costs, so typically you would split those half and half, right?
Right.
But if you have a situation where one person is just living in the house, you could argue, well, you know what? No, you wouldn't be able to in this case, because if you wanted to, you could go live on the property too. So he hasn't ousted you.
Right. That was I wanted to be sure about that because it kind of seems unfair, but at the same time, it's really not, because he's not told me I can't come. You know, I could just come crash his place and hell, I'll just go live with them, you know?
Right.
Okay.
Right. And at any point in time, you can go and live with them. That's the.
Okay. So if he would oust me though and tell me you're not allowed to come here, that's where we would have the issue, and that's where he would probably, or not probably, he would have to pay me rent and pay the expenses by himself because he's now denied me the right to use it.
Right. There would be, and so it depends on the jurisdiction as to how exactly it's calculated. But yes, right, like whether or not he would have to pay you rent or if it would be a credit, right, to offset the reasonable value. So if you look at $399,
I
the
have a
court
question.
goes through, yes.
So co-tenants can decide, right, what their rights and duties are going to be if they agree.
Correct.
So say Brady and that hypo, like they come to an agreement, Brady and Jacob, and they say, okay, for the next 6 months, Brady, you're going to live there exclusively, but you have to pay all of the maintenance cost of living there. And they can do that, and Jacob wouldn't be considered ousted, right?
Mhm.
Okay, just making sure.
That clears up the way this works in like real life. Now I'm good with that.
Yeah, but I'm looking back at this case over, and I'm trying to look at the language just to make sure, because I felt like in Estevez they discussed it, and I don't know if this is the majority rule though. In Estevez on page 399, they talked about how even if there was an ouster, there was not an ouster, sorry. If a tenant, you know what, let's say a tenant in common can live on the property for free, but if they're demanding the non-occupying tenant pay costs of maintenance, then the non-occupying tenant would get a credit to offset the reasonable value of the occupancy. So it looks like even at, I retract my statement. It looks like at least for a tenant in common, if there is a sole occupying tenant, co-tenant, then the non-occupying co-tenant would get a credit for the reasonable value of the occupancy. And then any maintenance costs would be deducted from that. So this is more like real life. In my experience on bar exams, the answer is usually, unless otherwise specifies, they share in the costs, right? That's usually the bar exam answer.
Okay.
This case is indicating, though, like some courts agree with you, Jacob, in that it's unfair to have to hold that even if the co-tenant doesn't get rent, that they should not be on the hook for the expenses, right?
And that's how I thought about it because I mean, why am I going to have to pay his water bill when he's the one living in the house?
Right. So I don't know that water bill would be considered, but it's more about repairs. The questions are usually about repairs, not about, because that is something that he puts in his name, and that is something that travels with a debt that travels with him if he doesn't pay it, as opposed to being on the property. So that seems like it's something that he's purchasing. But let's say there's the questions you're more likely to get are repair questions. Whose duty is it to, like, there's going to be reasonable repair and maintenance of the house? Then who needs to pay for that? And that the reason that is a little bit, you can kind of see it a little bit as a fair thing, is that let's say you buy a house built in 1910 and the windows haven't been changed in 50 years. Like, eventually the windows are going to need to be replaced, and they're going to need to be replaced regardless of whether or not Brady had lived in the property.
Right. That makes sense. Okay.
Makes sense?
Yeah. Yeah.
Where these questions come out of, as opposed to like bills like that, because that's something that would be his own personal liability. So think about repairs.
Okay. Okay.
The, I don't know. The roof starts leaking, right? Then who has to pay for the leaking roof?
Okay, yeah, that makes sense. I appreciate that. Thank you.
Yep, no problem. All right. I love these last two. So two people say, do these people get punished for conveying land to multiple people? Does this actually happen in real life? So it does happen in real life, otherwise we wouldn't have these typos. How commonly it happens, I'm not sure. It is fraud, right? So it is a crime to do these things. What happens more often than not, though, is we have people who just forget to record, right? And particularly in, so like, let's take my house, for example. So my house here in North Carolina, I bought it from somebody who had it, he got it in a will from his uncle, who had gotten it in a will from, a grandmother, something like that. So it had gone through family members, right? And it was just kind of passed on. Well, you don't know that the chain of title is correct in situations like that. Because sometimes, like Barbara was talking about in our conversation, people may not record the deed properly. You might have, especially, I think the problem arose more in like the West, in the Wild West, and in the South probably, when you had a lot of these just family informal deeding of property. And so a chain of title issues like this can happen. You also have some people who, let's say in a deed, they convey a property in life, like the inter vivos conveyance, and then like some of the cases we've looked at, then the question is, well, I changed my mind and I took it back, or I wasn't sure if that conveyance was actually true, it wasn't recorded. So some people, it isn't as much of a desire to commit fraud as it is just a misunderstanding that is a legal conveyance when a deed is given over, or when, even if it's recorded. And so they then also will the property, or they forgot, right? That happens as well, I guess. So yeah, I don't think it's super common. I just think it's, as an attorney who is doing whose job it is to make sure the chain of title is correct, you want to make sure that there is not a problem. And most of the times the problem is not, again, an issue of fraud. It's like, what problems are it? Well, you heard the Baker Barker problem that Barbara talked about, where she was doing a deed, a title search, and the deed was filed under Barker instead of Baker or something like that. And so there are, so you have to find holes in the title and stuff like that. But as far as when it's somebody who is who's doing a transfer like that because they're trying to commit fraud, it happens. How often, I don't know. I'd have to look it up. But yes, it is a crime.
Professor, about the Baker Barker thing, just to clarify, because I know we talked about it briefly, but if like the recording clerk messes up, that's still notice, right?
Yeah.
If the recording is proper and specific and everything's there, but the clerk just files it in the wrong place, that is not going to make a bona fide purchaser in the future, right?
Correct. It is still.
Just want to make sure.
Yeah, no, it is still a proper, and that's why, like in the states I've worked at, the filings are done by property number. And so I found this very odd when I was talking to Barbara. She was saying, there's a grantor grantee index. You look at the names, because in Nevada I just pull up the APN number and everything comes up, right? Everything. But you could record incorrectly by getting the wrong putting the wrong APN number because it's like a 9-digit number, and you missed one of the numbers you're recording against another property. So I'm sure that happens. More often than not, but it's not as complicated. Doing title searches isn't as complicated as it is when you have to look up each grantor's name.
But you have to admit that, like, if you are selling property for money and you do that multiple times, that's got to be fraud. There's no mistaking that, right?
Yeah. Oh, yeah.
Yeah.
Absolutely. Yeah.
Okay. Because that's kind of what the hypos are set. Like S conveys to D, and then S conveys to B. And, you know, I just, it made me laugh doing the problem. So I had to ask that.
Yeah. So it is fraud, again, unless there is some, other explanation, like S thought they were giving half of the property or they were doing a co-tenancy or that kind of thing. But yes, if it is as written, it is fraud.
Yes. S is a bad human being.
Agreed. Very much so. All right. Well, I think that's all I've got for you. My migraine's starting to come back, so I need to go take some medicine, but I am available if you all want to make an appointment. I have changed the settings on my Microsoft bookings so that you only need a 2-hour notice if I'm available in order to, like a 2-hour lead time in order to make an appointment. So any other quick questions before we go? Aside from that, if you all could just make a appointment for any other complex questions.